Now, during the pendency of this divorce, is it true that your mother passed away?
When did my mother pass? Yeah. No, not during the divorce. She
Okay.
passed when we were still together.
Okay. Now, okay. Did you inherit a property known as 10053 South Carpenter in Chicago, Illinois?
No,
Okay. Did you acquire any portion of that property at
no,
any point in your marriage? Okay. Did you report rental income from that property to the IRS?
yes.
Okay. And why or how did it come to pass that you received rental income from that property?
My mom wanted me to have the house. My niece was living in the house. My sister was living in the house. Some more people were living in the house. My sister never gave up the house. We had I think it's called a executor. She was in Chicago with my sister, going back and forth with my niece, but basically we just left it alone because it was too big of a hassle. So I never got the house. And I believe now my niece, my nephew, and probably some other people, my sister, are in the home.
But at one point you told the IRS you got rental income from it, right?
Correct.
And you did, right?
Correct.
Okay. And do you still receive rental income from that property?
No, that was very short-lived.
Okay. Well, how much did you receive?
I don't know. Was it maybe $600, $1,200 or something like that?
In total?
Yes.
Okay. How much is that property worth?
I have no idea.
Have you ever paid taxes on it?
No.
Is it in an urban area of Chicago?
I'm not sure if it's in an urban area or not. I don't know how they define areas. I've been gone for a while.
Have you ever visited the property?
Yeah, I used to live there.
Oh, is it a nice place to live in?
To me, it's nice. Yeah.
Okay. So it's a suitable house.
I don't know what it's like now. That's been probably 19 years ago. I can't tell you the conditions of it now.
But you know that some people still live there, right?
I don't know that for certain, no.
Okay. Do you own any assets that you haven't testified about today?
No.
So if the judge were to award Mr. Isom all of the assets you haven't testified to, you wouldn't have a problem with that because you've disclosed everything, right?
Correct.
And do you owe any debts other than the debts you've testified to today?
I'm sure I do.
Well, what might you think those debts are?
You've got coronavirus that's been existing for 18 months. So I'm sure I have some bills out there.
But you don't know what they are.
I can tell you that I'm sure it's an electric bill, could be alarm. As I told you, my rent on my lease that's in arrears, credit cards here or there. So yes, I'm sure there's some debt out there.
Do you think there's anything over $5,000?
My rent definitely is over $5,000.
Okay, anything over 10?
Yeah, the rent that's in arrears is $93,000.
Who should be responsible for that?
I'm responsible for it.
Okay, so if the judge in your final decree says you're responsible for that, you'd be okay with that?
Yeah.
Okay. Now you have one car in your possession, correct?
Correct.
And are you asking to keep that car?
Yeah.
Okay, and you're okay with Byron keeping the car in his possession, right?
Yes, I think initially, in the paperwork that you referred to from September, what was the date? September 22nd of 2016. It says right there, what Byron's responsible for and what I'm responsible for on page 2.
Okay.
Byron shall be responsible for the timely payment of the following: the time payment of all debt associated with his residence located at 25406 Richmond Falls.
If you could hold on, I'm sure the judge is going to give you an opportunity to respond.
Oh, okay, yeah.
So, and each of you should be responsible for whatever loans are on those cars, right?
Correct.
Okay. Do you have any financial accounts right now?
Yes.
What kind of financial accounts do you have right now?
My Chase business and my Chase personal.
How much is in your business account?
I think it's minus $1,100.
And how much is in your personal account?
Probably $700.
Are you asking to keep those accounts?
Yes.
And should Mr. Isom be allowed to keep his accounts?
I'm not sure. I don't know what's in his accounts or what he's asking.
So you're sure you should keep your money, but you're not sure if he should keep his money?
No,
basically.
What I'm not sure of is what I previously discussed. If he feels that he's obligated to my assets or money during the marital existence, I would also ask for his assets during that same marital existence.
Do you want to keep your business? Do you want to be awarded the LLCs that you have, or the LLC?
Well, yes, they are my LLCs.
And who should be responsible for debts associated with the foreclosure, such as attorney's fees and court costs? I'm sorry, attorney's fees.
Byron and I both.
And that's your contention, even though you didn't pay the mortgage?
That is correct. No, it's not that I didn't pay the mortgage. I didn't pay probably 6 of whatever number of payments were made once I was no longer employed. So I paid from 2008, including the $80,000 down payment, through 2019.
Now, if you keep your LLC or the LLC, don't you think that you should be responsible for all of the potential liabilities associated with the LLC?
Oh, yes, I said yes.
Okay. Let's see. Now, have you given any gifts during the pendency of this divorce?
Have I given any what?
Gifts. Have you given anybody or any organization money?
Oh, I'm sure.
What kind of gifts have you given?
Well, I do charity, usually every year, probably with the exception of last year in coronavirus. I give clothes, shoes, different women's shelters. Yes.
What's the most amount of money you've given to charity during this lawsuit?
Oh, I have no idea. Again, I would have to go back and look for every year since 2016.
Have you ever given money to a charity called Windsor Village?
That's my church. Yes.
Okay. And you give them money weekly, correct?
Not recently, but once upon a time, absolutely.
So would it be fair to say, as of your bankruptcy petition, you swore to the bankruptcy court that you gave them $75 a week?
If that's what I said and that's what's written down, that would be correct.
Okay. And you made a donation to AmVets for $400, right?
That's probably some items that they picked up. They use furniture, home appliances, old TVs, shoes.
Why is it that you were able to give to charity to Mr. Isom's detriment?
What do you mean give to charity due to Mr. Isom's detriment?
So why is it you'd give $75 a week to a church rather than put it towards one of the debts that you owe or the community debts that you owe?
Well, I think what you just asked me about church was in 2019.
Yeah.
When are you asking about the church?
Your home was foreclosed upon in what year?
I think maybe 2020.
So you would have been in arrears in 2019 to the mortgage company?
Again, I would have to look at the different specific dates because they can start the process and then you can pay them and then this and the other. And I think by the time I got maybe 2 months or 3 months behind, that's when I told you I called them and I said, you know what, I'm not going to be able to catch up. So I believe it was 3 months behind.
So you were 3 months behind when you were giving money to charity?
No, I would have to look at the dates. What date is that on the bankruptcy?
Your bankruptcy petition was filed June 3rd, 2019.
And so whatever church payments that your church offerings and tithes, I don't know if there's a correlation between a year or two later and 3 missed mortgages.
Okay. Were you able to figure out how much money you gave to your daughter in terms of tuition, savings, or other expenses?
I wasn't able to figure out dollar amount, but I did call her to ask if she just remembered. A lot was ACT prep, college prep, as well as a couple college taking courses to prep you for the class.
Mhm.
She was also in theater, and her current college tuition right now, as I told you, she's at a private Catholic college. Annual tuition is $43,000.
43,000. And how long has she been at that college?
3 years.
And have you been helping her the whole 3 years?
Yes.
And by helping, do you mean paying part of it or all of the tuition?
A little bit of everything. You've got travel, books, fees.
Do you know if your daughter has any student loans?
Yes, she has some student loans.
Some. Do you know how much she has in student loans?
I don't. I think of maybe a $5,000. I'm not sure. I
Okay.
know that with coronavirus and the CARES Act, they gave certain students some funds.
You're aware of Mr. Isom's request for a money judgment, correct?
Well, you and I discussed that yesterday, and I believe that that's been the delay, kind of getting this thing to where we are today. But I've talked to Byron numerous times, and I told him from even the beginning paperwork, I was always able to take care of my businesses the way that I have. Byron right now definitely has more monthly income than myself. He's been afforded a great life, and I'm not even financially in position to try to make any type of agreements. And he's been doing okay for 5 years, so there's no need to even think that he would be in need or to put myself in a position to try to make some type of agreement with him financially.
I think you answered my question, so I'm going to go ahead and pass you as a witness.
Well, why don't we go ahead and take our afternoon break so that Ms. Lewis will pick up with your testimony, and then let's take a 15-minute break, and we'll resume at 3:15. We're going off the record.
Thank you.
All right, if we can get our videos back up and running, we'll get started. Okay, Ms. Lewis, you've just been passed as a witness, which means if you would like to provide any additional testimony, it's now your opportunity to do so. So if you'd like to give me testimony, you may.
Okay, let me get my volume here. Can I call Byron as a witness?
Well, you're not calling witnesses right now. You're on the stand. So they were questioning you. And so technically you get to question yourself now. If you'd like to ask yourself any questions, I don't expect you to do it question answer. You would just talk and talk in the narrative. If you hear Mr. Chapman object, though, make sure that you stop talking. Don't try to finish your thought until I get to roll in the objection. You don't have to give testimony. I'm just letting you know that you have the ability to do that if you'd like to.
Okay, only thing I would like to add is I was able to discover 4 of the babysitters' names that I would like on record. They were Angel, Hunter, Tori, and Taylor. They were all my babysitters from when the time Amber was in 6th grade through high school. And I did not get a chance when Scott was going through the report of the different creditors, notably the ones for check writing services. Byron has frequently visited several of the Louisiana casinos here in Texas, as well as those in Vegas. So that just needs to be added to the record. And that is all that I have.
All right, Mr. Chapman, any redirect of this witness?
No redirect.
All right. All right. Thank you, Mr. Chapman. You may call your next witness.
I call Byron Isom.
You may proceed. Mr. Isom, you'll need to unmute.
Hey, I'm here.
Okay, Mr. Isom. You heard throughout the course of today Mrs. Isom's testimony. Have you heard anything that is inaccurate or incomplete?
I know that she had 3 businesses, and one of them is in Pearland, where she is now. And she only admitted to having 2. But there were 3 center stage galleries. Other than that, I can't think offhand.
Okay. As of today, do you currently own any real estate?
No.
Do you have anything like a timeshare or a condo or real estate interest of any kind?
Well, we had a timeshare together in Florida, but she got custody of that in the separation agreement. So I know my name is still on it because the people keep writing me about the money, but she got custody of that timeshare in the separation agreement. So I don't have anything to do with that. I don't know.
Do you want the timeshare?
No.
Okay. Okay. Do you have any bank accounts right now?
Yes.
Who do you have accounts with?
I got an account with Chase. I got an account with First Community Credit Union. I got an account with Houston Federal Credit Union, and I got an account with TDECU.
Okay. How much is in your Chase account?
It's a total of $400.
How much is in your First Community account?
My First Community account is it's about $800.
How much is in your Houston FCU account?
$36.
How much is in your TDECU account?
That account has approximately $1,200.
Say that one more time.
$1,200.
Do you have any brokerage accounts or mutual funds or anything of that nature?
No.
Okay. And of course, you want to keep your pension from the United States Postal Service.
Yes, sir.
Okay. And of course, it's your contention that the VA disability payments and the Social Security payments you receive are not subject to division.
No.
Okay. And so, of course, you want to keep all that. Correct?
Yes, yes, absolutely.
Okay. And you have a life insurance policy, don't you?
I have a life insurance policy attached to my retirement from the federal government. That's the only policy I have. And I have an amendment to my retirement. I paid like $300 a month for Stacy to receive my retirement upon my demise. And that is irrevocable. She would get that money upon my death. And
Okay.
there's nothing I can do about that. She's going to get that.
Okay. But with respect to the underlying policy, it has a face value of about $10,000, correct?
Right. Right. It's just enough to bury me.
Okay. And what car are you driving again?
I have a 2012 E350 Mercedes. With
How many miles?
300,000 miles on it.
Is there a note on that car?
Yes.
How much is left on the note?
How much is left? It's about $2,500.
Okay. So do you want to keep the car?
Yes.
And are you willing to pay the note associated with it?
Yes.
Okay. Now you've got some furniture that's worth about $700, correct?
Yes, sir.
You want to keep that?
Yes.
And the electronics you have are worth about $200, right?
Yes.
You want to keep those, right?
Yes, sir.
You've got possession of some watches worth about $85, right?
If that, yes.
Okay, you want to keep those, right?
Yes, sir.
Now you have some credit card debt, correct?
Yes, I do.
How much credit card debt do you have?
I have about $4,000 in credit card debt.
And who do you owe that to?
I owe that to Houston Federal Credit Union.
And who should pay that? Okay. Do you owe any money to the Internal Revenue Service?
Yes.
How much do you owe them?
It's currently it's about $19,000, but that is going to change because I haven't filed a couple of tax returns, so that's going to change. It's going to be a lot more than that.
Who should pay that?
I didn't hear your answer. What did you say, Mr. Isom?
I should pay my IRS debt.
Okay. Now, is it your contention that about $369,703 was squandered from the profit sharing plan?
Yes, it is.
And who should pay that?
Stacy should pay it.
Okay. Now, is it your contention that about more or less $211,000 was squandered in equity that was put into the Cold Hollow Lane house?
Yes, it was.
And who should pay for that?
Stacy should pay for that.
And you heard Mrs. Isom's testimony about the $30,000 in the EEOC settlement she received, correct?
Yes, I did.
Should you receive any portion of that?
Yes, I should.
How much should you receive?
$15,000.
You heard her testimony about the $6,000 she received from selling a car.
Yes, I did.
And how much, if any, of that should you receive?
$3,000.
Okay. Is there any other property you want that we haven't discussed?
Hello. Oh, okay. No, there's nothing else.
Are there other debts that exist that we haven't discussed?
No, I don't.
Is there anything else you'd like the court to know before I pass you as a witness?
I would like the court to know that I went into this marriage knowing that I was going to be in a support position because my wife was in an upwardly mobility job. And I knew that when we transferred to Texas, I would have to reinvent myself and I would have to find work and I would have to be in a position to support my wife while she made the money that she made. And I just want to let the court know that although our marriage is irrevocable, there should still be some compensation due me from all the money that she squandered, all of the support that I gave her in her business, all the time and the work that I put in and never took any money out of the business. That's all I got.
Okay, and lastly, before I pass you, let's talk about attorney's fees. When you started this process, you hired Playcheck Law, correct?
That is correct.
And over the course of this process, Mr. Playcheck is retired, right?
Yes, he has.
Okay. In total, how much did you pay to Playcheck Law?
Before he retired, I had paid somewhere in the neighborhood of about $20,000.
And since I've taken this case on as lead counsel, how much have you paid to me?
I have paid, I would have to go back and look at my records, but I know that I still owe you, and I plan to pay you whatever I owe you whenever we tally up.
Okay. And are you asking that the court award you attorney's fees as part of this divorce?
Yes, I feel like I'm due attorney's fees because this matter could have been settled 5 years ago, but due to delay tactics and fraud that my ex-wife to be committed, it prolonged this process and cost me a lot of money.
Okay. At this point, I'm going to pass Mr. Isom as a witness.
Mr. Isom, I need to know what you said that there was equity in the house squandered. What was your value that you used for that equity?
It was over $200,000.
That wasn't the testimony I heard. Do you remember what you testified to as far as how much you believe the equity was? You think the equity was $200,000 when it was foreclosed on?
Yes, when it was foreclosed. I really don't know offhand. I mean, I would just be making a guesstimate.
Okay. All right. Ms. Lewis, it's your witness. You can ask Mr. Isom questions.
Okay, Byron, we'll just stay in that same vein. Byron?
I am here.
For the home at 9218 Cole Hollow Lane, you do remember we talked about the purchase price. We talked about the down payment. The house roughly $380 when we purchased it. I put the $80,000 down. That brought it down to a mortgage on roughly $300,000. How would you arrive at the equity figure, whatever it is?
I don't, I'm just guessing. I don't know as a matter of fact, because you handled all of that. I don't know.
What do you mean I handled all of that?
Well, you handled the house note payments. You
Okay.
refunded the house. You
Say
did.
that again?
You handled all of the household finances.
Okay, but and I can't hear you. I don't know if it's the fan or your phone. It sounded like you said I refinanced.
No, he said you handled all the finances.
Oh, okay, thank you. So for the record, there was not 200 and when they foreclosed on the home, there was
I'm
no
going to have to
equity.
object to this form of testimony.
Sustained. Miss Lewis, you're going to get a chance to call yourself again if you'd like to, and you can
Okay.
tell me those kinds of things. Right now, I just need you to ask any questions you have of Mr. Isom.
Okay, Byron. Byron?
I am here.
Oh, I didn't know that. I can't see on the screen. Are you familiar with Aaron and Devaney Glenn?
Yeah,
And how are you familiar with them?
they were our neighbors.
And who is Aaron Glenn?
He's Devaney's husband.
Do you know what he does for a professional life?
No, I don't.
Oh, have you spoken to him or invited him over to the house or ever participated in barbecues with him?
Invited him to my house?
Yes.
No, I've never invited him to my house.
Have you ever seen him in our home and had
Yes,
a conversation with him?
Yes, I have.
Do you have any idea what he does for a living?
He's a professional athlete,
What type of professional athlete?
a high-paid professional athlete.
Do you know what type of sport?
Football.
Do you know what league?
Your Honor, at this point, I'm going to have to object as to relevance.
What's the
Well,
relevance?
there's relevance. I'm going to connect Byron and some of what he's already stated. And Scott, when you asked him if there was anything that was missed or left out, he said no.
Don't talk to Mr. Chapman. You only address the,
Oh.
what's relevant about this?
Scott, when we opened up, he asked Byron if there was anything in my statement that was missed or not said, and Byron said no.
All right, objection to relevance is sustained. Let's move to a new topic, Ms. Lewis.
Byron. Byron, are you still there?
Yes, I am here.
You said they were neighbors in our subdivision or
Going to have
different?
to renew my objection at this point.
Overall, I didn't hear the question. You said, can you repeat the question, Ms. Lewis?
Byron was saying that he knew Devaney because she's our neighbor. And I was asking him a neighbor where, in our subdivision or in Houston or St. Louis?
I don't see the relevance of what is this lady's connection to this case in y'all's property? What I'm doing today is dividing up properties and debts. How does she connected to the case, Ms. Lewis? If you can tell me, I may allow you to question him about her, but I'm trying to find the relevance.
Because they live in a different subdivision, probably 3 or 4 subdivisions over, where those are the home values, but the block that we lived in, no, the home values were not anywhere near that type of equity.
Okay, the objection relevance is sustained. Let's, you can address it a different way as far as the equity of the house, if you want to address it. He's already said he's guessing, so.
Okay, so I'll move on. Byron, and Your Honor, I'm gonna go back to when Scott asked if anything was missed when he started speaking with Byron, and connect the relevance that Scott is tying my debt and that credit report to Byron's debt on that credit report. Byron,
Okay.
are you familiar with the checking companies listed on that credit report?
I saw some credit check companies on there, but I don't know. I don't know how they associate themselves with me.
Would a checking company for bounce checks have reason to contact you regarding bounce checks?
Objection calls for speculation.
Sustained.
Byron, do you write checks at casinos, and have you during the marriage written personal checks at the casino window for cash?
Yes, I have.
In how many states?
Three:
And which states are those?
Missouri, Louisiana, and Nevada.
Would there be any in Memphis or Mississippi, wherever those casinos are?
Maybe. I don't know about Memphis. I don't know about Tennessee. Maybe Mississippi, but I don't remember.
Okay, so you said 3 states, and write those down. Missouri, would that be the state of Missouri?
The state of Missouri,
Louisiana, and Nevada.
the state of Louisiana, the state of Nevada.
And how often would you write checks at casinos in those 3 different states?
Are you talking about during the marriage? What
You
time?
can do during the marriage, you can do while we've been separated.
Okay, while we've been separated, I haven't written any checks.
Okay, so if some checks have been returned and asking for payment, they could have been written previously.
Right, but I don't have any outstanding checks.
When you say don't have any, you're speaking present day,
That is correct.
2021?
That is
So
correct.
throughout the marriage in those 3 different states, how many checks would you say that you have written to those different casinos?
Probably about 4 or 5.
Collectively or at each casino?
Collectively.
So Missouri, we lived there up until 2008. Nevada, and then Louisiana. We didn't move to Louisiana or move to Houston until 2008.
Objection argumentative.
Sustained.
So between 2008 and 2016, Byron, would you have frequented the Louisiana casinos or others?
Louisiana and Las Vegas.
Okay. And how often would you attend, not just write checks, but probably go to those casinos?
I went to Las Vegas once a year, and I went to Louisiana probably once every 6 months.
Okay. Have you heard of Coshada?
Yes, I have.
How many times would you say that you went to Coshada in a year's time?
I would have to speculate, say about 4 or 5 times. I don't know. I didn't keep count how many times at the casino.
What about La Berge?
I didn't keep count. I don't know. I mean, once a month, maybe.
Once a month, maybe for La Berge,
Yes.
and then Isle of Capri.
Once a month. I didn't keep track. I didn't keep a tally.
Okay. But would it be fair to say roughly once a month you frequented the Louisiana casinos, and then once a year, you went to Las Vegas, Nevada.
Right. That would be right.
So for Las Vegas, Nevada, what duration time span would you spend at the casinos in Nevada?
I would be in Las Vegas for a week, but I wouldn't be in the casinos for a week. I visited Las Vegas and we did other things other than gamble.
So maybe a week's vacation?
In Las Vegas, yeah, but in the casinos, I may have visited the casinos 2 or 3 times during that week.
Okay. And then for the monthly trips between La Berge and Isle of Capri and Coshada, how long would the duration be for those trips?
Those trips, very rarely would I stay overnight, but those trips were turnaround trips. If I went, I came back. If not that day, sometimes the next day.
So some would be same day and some might be overnight for the next day.
Yeah.
And then how many miles is it between Houston and Louisiana?
It's 95 miles.
Okay. And you said your current car, you've got about 312,000 miles?
Yes.
Objection. At this point, Your Honor, I'm going to object on the basis that this is repetitive, cumulative, and largely irrelevant to the finances of gambling, which may be remotely relevant.
Overruled, because you addressed it on direct, but she hadn't addressed it on cross. I'm going to let her address it. But I can tell you, the court heard that he had over 300,000 miles on his vehicle. But sir, you may answer that question. She's asking if you have 312,000 miles on your vehicle.
Yes, I do.
Okay. And previously you stated that the Uber work that you've been doing, that work is inconsistent.
That is correct.
So how would you have so many miles on your car?
Well, when I bought it, it had over 200,000 miles on it. And I drive a lot. I go to St. Louis. I drive to Louis. I got relatives in Dallas. I got relatives in Biloxi, Mississippi. I drive a lot.
Okay, that's it. I'm sorry, I said Tennessee. The casinos are in Biloxi, Mississippi. Correct?
There are casinos in Tennessee, in Memphis, and Biloxi.
Okay. And you know what, my phone, a little thing is dying here. Let me plug it up. I don't want to interrupt. I'm sorry.
Okay.
The power light just came on. Byron, along that same vein, you drive a lot, you visit family, you go to Dallas, you go to St. Louis, and you also said your sister lives in Biloxi, so sometimes you do a lot of driving there.
And I drive to California. I got a sister in California.
Okay. What kind of car did you have prior to the 2012 Mercedes-Benz?
I had a Lexus ES350.
Did you acquire that during the marriage?
Yes, I did.
Remember roughly what year?
It was 2010.
Okay, so about 2 years into the marriage.
Yes.
When we moved from St. Louis to Houston, did you bring your car or have your car shipped?
No.
Did you have a car prior to the Lexus?
Yes, I had a 7 Series BMW.
What year?
I think it was a 95.
Oh, okay. So by the time we moved, that was what, about 13 years old?
Yes, it was.
So you got a new car in the marriage, which was a Lexus, you said 350 here in Houston.
That was not a new car. It was used. It was 3 years old when I got it.
Well, that's fairly new in car terms, but I'll keep moving. When Scott asked and he went over your bank accounts and what amount, what assets you have, did you tell Scott that you had a safety deposit box?
Objection. It calls for attorney-client privilege communication.
Sustained.
Do you have a safety deposit box, Byron?
I had one, yes.
You had one when?
I had one. Got a notice the other day. They closed it out, so it was. I got the notice right here. What it says. It said permanently close your safety deposit box. No, actually, I still got it. It's open until December the 9th.
Just now, when Scott was asking about assets, did you tell him whatever is disclosed in your safety deposit box?
Objection. Again, the question calls for attorney-client privilege communication.
Overruled. I think she's asking about his actual answers to the direct examination. So
Correct.
you're not asking about what they talked about. You're asking about what he testified to. Is that correct, Ms.
Yeah,
Lewis?
just like 15 minutes ago.
Objections overruled. You may answer that, sir.
There's nothing in my safety deposit box. There's nothing been in my safety deposit box since I took my passport out of it like 6 years ago. There's nothing in there.
Is it free? Is it a free service?
Yes, it is.
So there is no payment that's due on it or was due?
I don't know because I haven't touched that box in over 6 years. So I don't know if there's any money due or not. I just abandoned the box.
I don't recall. Did you let me know when you opened a safety deposit box or had one?
No.
But so you opened up a safety deposit box to secure what?
My passport.
Okay. That is all that I have.
Mr. Chapman, any redirect of this witness?
Briefly, Mr. Isom, you attended mediation that was ordered in this matter, correct?
Yes, sir. And I paid for it.
How much did you pay?
I think it was about $200, something in that neighborhood. I don't quite remember.
You appeared on time?
Yes, sir, I did.
Okay, and you waited there with the mediator and myself?
Yes, sir.
You waited for about 20 minutes, correct?
Yes, sir.
Did Mrs. Isom, did she ever appear?
No, she did not.
Are you asking that mediation fee be retaxed against Mrs. Isom?
Yes, I would like that.
I pass this witness.
Ms. Lewis, any other questions?
No.
All right, Mr. Chapman, you may call your next witness.
I will call myself for the limited issue of attorney's fees.
All right, you may proceed.
My name is Scott Maxwell Chapman. I am an attorney. I'm licensed in the state of Texas. I was called to the bar on November 2016, and I've been a member in good standing ever since. I'm also a member of the Southern District of Texas in the Fifth Circuit. In addition to a JD, I have a master's degree, and that frequently informs my practice. About half of my practice at this point is devoted to family law. Although I now focus my practice on the San Antonio, Austin area, from 2016 until about a year ago, maybe two years at this point, my practice was principally focused in Harris County and the surrounding counties, and I would estimate about 80% of my practice at that point focused on family law. I'm familiar with fees charged in Harris County and surrounding counties for services like those that I have rendered in this case and like those that Mr. Placzek has rendered in this case. Unfortunately, in this case, since it spans the entire time I was licensed and slightly before I was licensed, my fees have changed throughout time. When I held a third-year bar card, I think my rate was billed at $90 an hour. Shortly after I graduated and became unrestricted, I think I billed $100 an hour for maybe 2 or 3 weeks. And then I billed $150 for a great deal of Mr. Isom's case. That escalated over time throughout the years to $200 an hour, which is the rate I think Mr. Isom was billed at when Mr. Placzek retired. When I went independent on my own, I increased my rates. I charge Mr. Isom $250 an hour currently for services rendered. A great deal of work has gone into this case. I want to say that over the history of this case, I have probably put in at least 30 hours of work myself. I can't speak to all of Mr. Placzek's work, but I have seen him work on this case. I am aware of the fact that he's gone to mediations and hearings in this case. And if I had to estimate, I think what I could estimate is I've seen him work at least 20 hours. I'm familiar with his billing. I've been familiar with his billing throughout the case. I know that he's charged $300 an hour. And over the course of my career, I have come to know that figure as customary and reasonable for the type of work involved in this case. Mr. Isom, apart from the $20,000 he testified to Placzek law, he has paid me approximately $1,800 to date. Since I have appeared as lead counsel, I have put approximately 15 hours into this case, not including my time today. It's likely that I won't bill all of that, but I anticipate billing at least 10 hours exclusive of my time today, which I intend to bill all of. For that reason, Mr. Isom is asking that attorney's fees be awarded in the amount of $21,500. This concludes my testimony as to attorney's fees.
Okay, Ms. Lewis, any questions of Mr. Chapman?
Can I just make a statement or they have to be in question form?
You'll be able to testify in a little bit once he rests
Oh.
his case. So it'd just be questions at this point.
I would just like to ask Mr. Chapman, when Byron acquired your senior firm and the other attorney that you said has since retired, that seems quite accomplished, were you guys aware that he was an Uber driver?
At the time I appeared as lead counsel, I believe I was aware that he's an Uber driver.
And I don't know if you could speak for the other gentleman that you said he started with, but that gentleman has since retired. But the two of you, go ahead.
Go ahead. I can't speak to his personal knowledge.
Other than you can attest to how many hours that you know that he put in on Byron's case.
I can attest to things that I've seen with my own eyes. That's all I can attest to for him.
And in the beginning, you said after law school, if you could, the dates you started at 90 an hour, then you went 150 and then out on your own at 200 an hour?
That's incorrect. Before I graduated from law school, when I held a third-year bar card, I believe my effective rate was $90 an hour, and it has increased over time since then.
And it has increased. How does that time relate to Byron and our case in this 5-year span?
I believe if you look back at the billing, those rates have increased over the course of 5 years.
When you say look back at the billing, is that something I have access to? I'm not familiar with your billing.
I don't know. I believe that your attorneys were served with some discovery that included invoices.
I personally have not had an attorney when I could no longer afford one. So instead of continuing on with that debt, that's why I'm representing myself, because I couldn't afford an attorney.
I don't understand your question.
Because I asked you, you told me to refer to the billing for when your rates changed. I told you that I don't have access to that. And then you told me that my attorney, which I don't have, probably has that.
I don't understand your question.
No problem. That's it.
Okay, Mr. Chapman, any redirect?
Yes, I will state that discovery was served on Ms. Cusick at the time she was representing Mrs. Isom. I know that some of that discovery included invoices. How much, I don't recall without it in front of me.
Do you pass yourself?
I do.
All right, Ms. Lewis, any additional questions of Mr. Chapman?
No.
All right, Mr. Chapman, you may call your next witness.
At this point, we rest.
All right, the respondent has rested, Ms. Lewis. That means that if there's any rebuttal witnesses that you would like to call, you may do so at this time.
Can that be Mr. Chapman himself? Or just
It could
Byron?
be- It could be whoever. It could be you, Byron. It could be you, Mr. Isom, or Mr. Chapman. You're in a rebuttal. You can call any witness you want to call.
I'll call Mr. Chapman.
All right, Mr. Chapman, you may proceed.
Mr. Chapman, on the document that you referred to, and please forgive me, I don't know the name, but it was entered into the court for roughly $369,000. On that report, that first column, do you see that is an investment report? Do you see the list of those stocks, bonds, and holdings as a first column, and myself probably as a second column under deposit?
Your Honor, at this point, I object to the question in as far as it extends beyond attorney's fees, which was a limited issue that I called myself to. I do not believe that it's professionally responsible for me to testify to facts that I don't have personal knowledge of or anything other than attorney's fees. Inasmuch, I refuse to do so unless you specifically order me to do so.
The objection sustained. If you can rephrase your question, Ms. Lewis, or
On the document entered with the $368,000, no, I can't do that.
what that document wasn't entered. It was just displayed. I don't think
Presented.
that document was entered into evidence.
Okay, on that, the second column under deposit for my name for the dates listed, that amount is 11,000, not 369, which belongs to those other accounts.
All right, Miss Lewis, I think what you may want to do is do that through well, I can't tell you what to do, but this lawyer is only testifying as to his fees. What you're questioning about doesn't have anything to do with his
Oh, we're
fees.
just doing fees. No, I have no questions there.
Okay, then Mr. Chapman, any other evidence you want to present since you were called as a witness?
No.
Okay, Ms. Lewis, you may call your next witness.
I'll call, Byron, are you still around?
Yes, I am here.
Okay, so from 2016, from the point of separation through current day, do you live in a shelter, hotel, apartment building that is considered not livable space?
No,
Where do you currently reside?
I live in an apartment
What part of Texas?
in Memorial City area.
Memorial City, Houston?
That is correct.
Is it Section 8 or assisted living?
No,
It is a traditional all income levels?
I don't know what everybody else does. I just know that I pay my rent.
Is it a senior living facility?
No,
Is it an assisted living facility?
I can't speak to that. I don't know what everybody else is doing. I just know what I'm doing over here.
Do you receive any type of public assistance?
No, I do not.
Do you receive food stamps?
No, I do not.
Okay. Are you familiar with the docket the attorneys drafted on September the 26th, 2016, when I think it's called agreed temporary orders?
I'm not familiar with that.
Okay, I'll read it to you. Page 2, it says, it is ordered that Byron Milson Isom shall be responsible for the timely payment of the following. The timely payment of all debt associated with his resident located at 25406 Richmond Falls Drive, Richmond, Texas, 77406. Was that a prior residence to where you are now?
That was a very temporary residence. That was my niece's house.
Okay.
I stayed there for a couple of weeks.
Okay. And now you live not with your nieces or by yourself?
No, I live with my nephew and a friend. The three of us live together.
Do the three of you split the expenses?
Yes.
Roughly how much is a rent a month?
It's about $1,600 a month.
What would you say your portion of that is?
My portion is about $500.
Okay. Then it goes on to say the timely payment of the debt on the 2016 Hyundai Sonata. Do you still have the 2016 Hyundai Sonata?
No, I do not.
Okay. Going back, I know you said you currently have a Mercedes-Benz, and prior to that, you had a 3-year-old Lexus car. When did you purchase the 2016 Hyundai Sonata?
I purchased that in actually that wasn't a purchase. That was a lease from Uber.
I don't understand it.
I take that back because I had two 2016 Hondas. I had a leased Honda from Uber, and then I purchased a Hyundai after the lease was up, the 2016, and then I purchased a Hyundai.
Do you remember when you made your purchase of, and I'm sorry, I'm reading Hyundai and it sounds like you're saying Honda. Are we talking about the same car?
Yes, a Hyundai.
A Hyundai Sonata.
Yeah, Hyundai Sonata, yeah. I had leased a Hyundai Sonata from Uber, and then I think in November of 16, November of 16, I purchased a 2016 Hyundai, and I turned in the leased Hyundai.
In November of 2016.
Right. I turned in the leased Hyundai in 2016. I gave it back to Uber, and I started driving the one that I purchased.
So what happened to the Hyundai to the Mercedes? When did you purchase the Mercedes?
I purchased the Mercedes in, I want to say July of 2018.
And did you keep the Hyundai Sonata from November of 2016?
I kept it until I purchased. Well, no, I take that back. It got destroyed in the flood in I want to say October of 17. Whenever the flood hit, I think it was October of 17. It was totaled out. It wasn't even a year old, and it was totaled out.
From one of the floods or one of the hurricanes?
Yeah. The one,
On the speaking with the 2016 Hyundai Sonata. Did you tell me that you purchased a car?
what?
Did you communicate to me in November of 2016 that you purchased a car?
No,
How did you finance a car?
I financed it through, I financed it through the dealer.
And what was the total that you financed, dollar amount?
I don't know. I think it was about, I don't know, maybe 25,000. I don't know. I don't remember.
Roughly 25K.
Yes.
And when it was totaled out, how much did you get?
Well, they didn't, I had gap insurance, but they didn't pay me what what was owed on the car. They paid me what the car was worth. And I had put so many miles on it because I was driving Uber that I had wound up, I had a loan balance of about $3,000 when they paid the car off, because I had so many miles on it, it wasn't worth what I owed on it.
So for clarification, you purchased a car in 2016.
Right.
It was totaled probably about a year later in a flood.
It wasn't even a year later. It was like 10 months later.
And you only owed $3,000 on a $25,000 car?
I had gap insurance. The insurance company paid most of the balance. They didn't pay it because the car had so many miles on it, it wasn't worth what I owed on it.
Okay.
So I still owed the finance company over $3,000.
Okay, so give or take, not too bad. The gap insurance saved you.
Oh,
if you only owe $3,000.
Yeah, the gap insurance saved me immensely.
Okay, but okay, yeah, that's not bad. So then, did you use that $3,000 to purchase the new car?
No, you're not understanding what I'm saying. After the gap insurance was paid, I still owed $3,000 to the finance company that financed the car.
Okay.
So they didn't give me $3,000 extra dollars. I still owed $3,000 on the car because the car had depreciated due to the high mileage.
Okay.
The car
so
wasn't
then,
what I owed on it.
So then when you purchased the new car, which I'm assuming is the Mercedes Benz, did you finance that car?
Yes, I did.
And who did you finance that with?
That's financed through American Finance Group. Some shit. Let me see
That's okay. That's okay.
American Finance. It's like 25% interest. It's
Lord.
high interest. Yeah, yeah. Well, the same way with the Sonata, it had 25% interest on it as well. So.
Okay. So what was the purchase price of that Mercedes with American?
It was $11,900. Yeah, here
And
it
you
is.
said, okay. And you said you owe roughly how much on that right now?
I owe about I want to say about $3,000.
Okay, so you've done you purchased it. Was that with financing or was that sticker price at 11.9?
That was sticker price at 11.9. The financing was 25%.
Ooh. So what's 25? what's 25% on roughly $12,000?
$4,000. So that took a $12,000 car to $16,000.
Okay, so in 2018, a $16,000 car that's financed, did you finance for 60 months, 72, or 84?
I don't remember. I think it was what's 5? Is 5 months 72?
5 months is 60. No, 5 years is 60.
No, I think I did 6.
Probably 72 months.
Yeah, I think so.
So if you only have a $3,000 balance current day, you have paid $13,000 on the car in roughly a year?
A year. I've had that car for 3 years.
Oh, okay.
Yeah.
I'm sorry, 2018.
Yeah.
Okay. So your balance is quite affordable at this point. And the car is still running in pretty good shape.
Well, I don't know about that.
Okay. Just want to circle back a little bit. So when they totaled out the Sonata, the Hyundai Sonata, the gap insurance helped during that flood. So you only still owe roughly $3,000, but you stated it didn't have as much value because of the miles that was on it while you were driving for Uber.
I'm going to have to object at this point because this is repetitive.
Sustained.
So was the year 2016 a good year for Uber driving? Byron?
I mean, it was okay for me. I mean, that was all I had. So
Okay.
it had me.
Okay. Did you ever tell me you are you still there?
Wait a minute.
Okay.
Yeah.
Okay, so looks like we got separated at some point in 2016, but you never told me about the purchase of the lease vehicle from Uber, the Hyundai Sonata, or the Mercedes-Benz purchases, the 3 cars.
That's not true.
Okay.
I had that Hyundai Sonata before I left the house.
Okay. But then when you turned it in or the flood and you had to purchase another new vehicle, you didn't convey that to myself.
I was gone. You put me out. I had been gone, 6 months.
Mr. Isom,
You can't curse in the courtroom.
Do what?
Okay, let me continue.
Yeah,
6
please,
months.
just continue, please.
Okay.
Mr. Isom, watch your language.
So
Sorry
Byron,
about Your
that's
Honor.
okay. I'm still continuing on.
Apologize for it because she's saying things that are not true. I had that car.
Hold on, there's no question on the floor. Wait for the next question.
Oh,
I'm still reading the agreed temporary orders. And then for myself, it says it is ordered the petitioner have the exclusive and private use and possession of the following property while this case is pending. The marital residence located at 9218 Cole Hollow, the contents of the marital residence, save and accept the items awarded to the respondent herein. It is ordered that the respondent shall vacate the marital property on or before July 10th, 2016, and may remove the items to him. I also got to retain my 2014 Mercedes E350 and the 2008 Cadillac Escalade. Bank accounts in her name to pay normally recurring expenses and minimum payments on any debt, and shall not make any extraordinary withdrawals unless agreed to in writing. Does that sound familiar, Byron?
yes.
Okay, that is all I have.
Yeah, well, you wait a minute.
Hold on. That's all the questions she has. Mr. Chapman, do you have any additional questions of this witness?
Mr. Isom, briefly, in 3 or 4 sentences, can you please explain the context behind that?
The context is, Phil, my attorney told me he wanted me out of the house that day. He did not want me to stay in that house. I told him I had 30 days before I could get out. He said, no, I want you out tonight. So I took everything that I could stick in my car and I left. I never went back to that house. She took all my clothes, all my shoes, all my important papers, all of my pictures, everything, and threw them away.
Okay, I pass this witness.
All right, Ms. Lewis, anything further from this witness?
Byron?
I'm here.
Hold on. Any other questions of this witness?
Yes.
All right, you may proceed.
Byron, who told you to get out that day?
My attorney advised me to leave.
Okay, but the orders that we had gave you a date, so you had up until that date to do whatever you need, because did you ever lose access to the home?
You changed the locks.
You're under oath.
Objection.
Changed the locks.
Okay, so did you have access to the home?
I don't know, because you changed the locks. I
How did
never
you-
went back to the house.
So when you came on that Saturday to grab your things with your friends, did you have access to the home?
Objection asked and answered.
Sustained.
Byron,
I'm here.
so at what point were you restricted from accessing the home?
I'm going to object. This has already been answered.
I think it calls for
Okay.
speculation as to when she changed the locks. He's not going to know that unless she told him, so sustained.
Okay, no further questions.
Mr. Chapman, anything further from this witness?
No, I'd ask for a very brief closing.
We're still, hold on, we're still on Ms. Lewis's case in rebuttal. Any other witnesses you'd like to call, Ms. Lewis?
No.
All right. I have one question with Ms. Lewis. So on the statement, it shows that you had $369,703.59 as of March 31st, 2017. And do you dispute that that's what you had the authority to withdraw from that account on that particular?
Yeah.
And why do you say that? Because it appears that
Um,
your vested account balance on that statement that you were testifying from, it says that your vested account balance on March 31st, 2017 was $369,703.59.
I don't agree, because I just don't know how to explain it. So when you receive shares from Walgreens, what they were doing prior to when they switched everything up, you got the value of those shares on paper, but you didn't get it in actual money. You only got the money for those shares whenever you sold them. So that may be the value, but depending on when you sold them, that's what you would get. So yeah, I was invested because I started with the company in 1992. So that probably is the total amount of maybe all of that at that point in time. But then whatever I withdraw from whichever, however they do it, that's when you get like the payout. So what Scott said, that I withdrew 90,000 or whatever that number was, that's why I said that number could be true, but it's not 300 and any amount of money.
All right, and you don't have any statements to show where that money went, is that correct?
Well, I think Scott has it from the deposition or whatever he had the last time we were in court. He had the withdrawals and the dollar amounts.
Okay. All right. All right, Mr. Chapman, any other questions after my questions of Ms. Lewis?
No.
Ms. Lewis, anything further before I let y'all give closing arguments?
No, I don't have anything yet.
All right, I'm going to let each side give me a brief closing. This is what you'd like to see the court do in this case. Ms. Lewis, you're the petitioner, so you get to go first. You can give me a brief closing of what you'd like to see the court rule on this case. You may proceed.
Thank you, Judge. What I would like to have ruled is just the marriage is dissolved. Whatever debt and finances that Byron has, he should be responsible for those, as he stated earlier. Whatever debt and accounts that I have, I should be responsible for those, as I stated. We don't have any children in the marriage. Byron's daughter is 40 years old or something. My daughter is in her 3rd year at DePaul University. I am a single mom. As you heard Mr. Chapman attest to, I was a very successful business prior to March 2020, which would have been my best year yet. But due to coronavirus, I've just been decimated. I'm currently unemployed. I did go out to acquire my real estate license in April of this year. I just passed because I think that's the way that I can probably make the most money the fastest to get myself back on equal footing. Byron has assets, bank accounts, cars, roommates to help him with his expenditures. He's not on any type of assisted living. I personally just applied for food stamps myself, first time in my life. And as I stated, my priority is getting myself back on equal footing, as well as taking care of my daughter. She used to have some support. Her father died in December of 20 as a cancer. She's an only child. So those are my priorities in life. I do not feel that I should pay Byron's exorbitant attorney fees, because this matter has always been simple. There was no property, no anything, really just us. And because of him and his shenanigans, that's why we're here today. And if he decided to select an attorney at $200 an hour, $150 an hour, a nice office on Kirby Drive, he should be responsible for that. He always knew what my position was. Scott, with access to my paperwork, and as he stated, my business, those first 4 years operated at a sheer loss. So I'm not sure who they thought should pay that bill or how they advised Byron. Me and Ms. Cusack had a conversation, because when my bill got up to me owing her roughly $2,500, we weren't going to continue because I wasn't in position to pay her and she wasn't in position to work for free. And as I stated, Byron has income coming in from disability, from Social Security. Looks like he's done quite well with Uber. He's been driving for over 5 years. He's put tons of miles on his car. So one would think that is panning out okay for him, since he's still continuing to do it. His debt is probably no more or no less than mine as a grown individual. He has debts from his personal matters, and I have debts from being a business person, in addition to being a mom and having to put in 24 years with a career. And throughout that career, Byron and I met. He was afforded a great life. He did not do anything probably other than the bare minimum, a pickup, a drop off here or there. I always had housekeepers and babysitters and nannies. The money that I made, I shared that money. We went on great vacations. We lived a great lifestyle. We ate out, we dined out, we had great clothes, jewelry. So all of that was shared. And for the last 6 years, he's been fine. He hasn't had to reach out for any type of assistance. He's got income and jobs and family. So I feel like he's in pretty good shape, and whatever debts he has, including his attorney fees, are his and his alone, as well as mine are mine and alone. And the one mediation that we missed, that was just a miss in communication, because I'm the one who actually scheduled it, tried to find the lady, I think through the Fort Bend Resolution Center, through Scott, and between emails and different cell phone numbers. I wasn't there because I didn't know about it. And I rest my case.
Okay, Mr. Chapman, closing.
Yes. Briefly, I'll say that my closing isn't directed to Mrs. Isom individually. As a pro se litigant, she has always shown me respect, and it's something I value. So it's not about her personally. What my closing is about what has happened to Mr. Isom. Is he perfect? No, we never intended to prove that.
Hold on, the Zoom froze up on me. You said your closing is about what's happened to Mr. Isom, and then you faded off. What was the next statement?
I said, is he perfect? No, we never set out to prove that. Has he kept up his end of this divorce process? We think so. He's been cheated immensely, and his only remedy at law is a money judgment to equalize the estates. And that's what we're asking for. The way we measure damages is the $369,703.59 that was depleted from the profit sharing plan. The $15,000 that Mr. Isom is asking for out of the EEOC settlement, the $3,000 he's asking for out of the car sale that was testified to, in the $211,200 more or less in equity that's been estimated. If you aggregate all that together, that's totals $562,939.61. And Mr. Isom, although he's retired from the Postal Service, can never in his lifetime hope to save that amount of money. What happened was, in this case, is that Mrs. Isom decided to quit her job for whatever reason, and a whole string of events, negative events, followed that. And the only person that suffered is Mr. Isom. Mrs. Isom's fortunate in that her resume, she can put all kinds of accomplishments, all kinds of experience with a Fortune 500 company that Mr. Isom cannot. And at the end of the day, it is not fair to him to expect him just to walk away after being cheated out of all of this. He's asking for his personal things, of course, his car, the things in his possession, his limited financial accounts. But at the end of the day, this has decimated him. And we hope that the court will see that and do something about it. I don't think that Mrs. Isom's characterization of the case is a fair one. There have been discovery issues all along. And we just got fortunate in discovering some of the fraud that exists. I'm sure there's been other things that have been hidden that Mr. Isom won't learn about until later. And that's unfortunate. But now is the time to separate these people and to make Mr. Isom whole. And that concludes my closing.
All right, thank you. But the court's going to take about a 10 to 15-minute break to review the evidence that was admitted and just make some notes. I'll be back with my ruling here shortly. So just sit tight and just come back in about 15 minutes, going off the record. I know I'm back early. I just have a question if Ms. Lewis is present, because I've got Mr. Chapman. I've got a question for you.
I'm here.
Okay, I'm just looking at the pleadings on file. I don't see that there was a counter petition filed by Mr. Isom. Is that accurate, Mr. Chapman? Have you-
Excuse me, my volume, something's wrong with my volume. I can't hear you. What?
He's speaking to you. He's speaking to your attorney.
Oh, I know, but if he can't hear me, but Mr. Chapman, do you see, or I don't see that a counter petition was filed in this case, just an original answer. Is that what you're?
That's not accurate. If you'll give me just one moment, I'll give you the date of the first amended counter petition. It's file stamped December 10th of 2017. It's a first amended, well, it's written as original petition, but it's signed by me on behalf of Mr. Isom.
What was the date on that? Because I have the first amended petition for divorce, but you said there's a first amended counter petition. Where is that? What was the date again?
It's December 10th of 2017.
All right, so in my file, it shows there was 11/22/2017 judge docket entry. And then the very next thing is for April 3rd, 2018, a motion for withdrawal of counsel. I don't see anything filed in December of 2017. Is that file stamped that you have?
Yes, I have a file stamped one. I can share my screen if you'd like to see it.
Yeah, I need to see that because I don't know if it's in, that's not in this case. It's not in my file. So if you can share the screen and just show me, maybe it'll help me find it.
Yeah.
Oh,
If you-
October 10th. I thought you said December 10th.
Oh, I'm sorry. It's been a long day. I apologize for that.
Okay, that's the one I was looking. I saw that there was a first amended petition for divorce. So this is,
It should have been captioned counter petition.
got you. Okay. All right. Let me review this document. That's what had me thrown off.
I apologize.
It's okay. No problem. Y'all can just sit tight. I'll be right back with you. All right, Ms. Lewis, when you're ready, and Mr. Isom, when you're ready.
I am here.
I'm here.
Okay. Let me get back. Reports back on the record in the Lewis and Isom matter. And both sides have closed and both sides have rested and given their closing arguments. The court is going to issue the following ruling. I need to set entry of this order. Mr. Chapman, I'm going to have you draft the order. You think you can get, if I give you an entry date of October 22nd, you think that gives you sufficient time to get the order in? Or, well, I mean, I could do October 15th or October 22nd, whichever date works best for you.
October 15th would work just fine for me.
Miss Lewis, is October 15th work for you? What that means is I'm about to give a ruling and both sides should write down what I'm saying. Mr. Chapman will draft the order, the final decree of divorce, and it will lay out what I rule. And then that, if you receive that before the 15th and both sides sign as to form, not saying you agree with what I do or that Mr. Isom agrees with what I do today or that Mr. Chapman agrees with what I do today. But if you and Mr. Chapman sign it as to form, saying we agree that's what Judge Bell said, then nobody has to come back on the 15th. The order will just be signed at that time. If there's a dispute though, let's say that I say you get $500 and you get the decree and it says you get $200. The best thing to do is to contact Mr. Chapman and say, well, Judge Bell said $500 and see if y'all can't work that out and come to an agreement on what I actually ruled. And if you can't, then everybody will appear back on the 15th by Zoom and I'll resolve any issues that we have with the drafting of that order. So Ms. Lewis, are you available on the 15th at 9 a.m. in the event that we need to have a hearing on entering the actual order?
Yes.
Okay. Then entry will be October the 15th at 9 a.m. And let me say this to both Mr. Isom and Ms. Lewis. I doubt, and most of the time in divorce court, each side leaves feeling like they didn't get exactly what they wanted. And that probably will be the case in this situation as well. But this has been a long, long process for both of you. I am happy that you're hopefully going to be able to close this chapter and move on. You've both been through quite a bit and both have had some financial struggles along the way. And my hope as a person is that things turn around for y'all and that closing this litigation helps you do that. The divorce is granted based on insupportability. Wife is awarded the timeshare in Florida and any debt or maintenance fees associated with that timeshare. Wife is awarded the 2014 Mercedes E350. That's the testimony I heard that she was driving, but she's awarded the vehicle in her possession and any debt on that vehicle. Husband is awarded the 2012 Mercedes E350, as well as the debt on his vehicle. Wife is awarded the bank accounts in her name or in the name of her LLC. Husband is awarded the bank accounts in his name. Wife is awarded the furniture, jewelry, and clothing that's in her possession. Husband is awarded the furniture, jewelry, and clothing in his possession. Wife is awarded any retirement accounts or IRAs that still exist in her name. Husband is awarded his federal retirement, all of it, except for any survivorship benefits that he's testified are allocated to wife. I understand she will have a survivorship interest in that plan, and she still gets that. But other than that survivorship annuity, 100% of the retirement plan goes to husband. Husband will be awarded his VA disability and his Social Security. Wife is awarded the 25-8 Management Group LLC, doing business as Center Stage Gallery. She's awarded 100% of the interest in that LLC, any assets of the LLC, but she's also awarded any debts associated with that company or that LLC. Wife is awarded any proceeds from the lawsuits and judgments or judgment against Olivia Corner, as well as Elysian at Sienna Plantation, that litigation. Wife is awarded all debts associated with the foreclosure of 9218 Cold Hollow Lane in Missouri City. Husband is awarded all IRS debt in his name, so that 19,000 that he testified about that he says is going to grow, husband's responsible for that debt. Wife is to pay all other debts in her name or debts that she's incurred. And husband is ordered to pay all debts in his name or any miscellaneous debts that he's incurred. The court does find that there was, and the court recalls the prior testimony of the parties as well, but there was $90,000 that was withdrawn from wife's retirement plan. And I know that the statement says there was 369,000, but the prior testimony showed that the portion of that was withdrawn by the company. And my recollection, and based on the testimony that I heard today, there was a concession that $90,000, at least $90,000 was withdrawn. Our recollection is it was like 94,000, but what I heard today as far as evidence was both sides saying that there was at least $90,000 withdrawn from that account. To me, that's prima facie proof that there was some fraud on the estate, and then the burden shifts to Miss Isom or Miss Lewis to account for where that money went, what it was spent on, and that wasn't done in this case. So the court is going to award husband a judgment of $45,000 to equalize the property division. That judgment is to collect interest at the maximum amount allowed by law until paid in full. I know that he's asking for money for a foreclosed house. I know that he's asking for money for the sale of an Escalade, but I can tell you, it sounds like both sides were selling and purchasing cars and doing all kinds of stuff without coming back into court and getting permission to do any of that. And so the court factored that in. I'm not awarding any additional funds for the foreclosure or for the Escalade being sold. And the EEOC, Ms. Lewis said that she spent that money on personal expenses. And based on the amount of debt that I heard about today, I don't doubt that she spent that money and that testimony was truthful. And the court found it was credible. So there's no wasting claim on the EEOC or on the foreclosure or on the Escalade, but I am giving it on the retirement account. Each party's ordered to pay their own attorney's fees. If there's any balances owed on those attorneys, the parties are responsible for that fee. And that, I believe, completes the ruling of the court. Any other assets that are out there that weren't divided by the court are subject to future division. You can put that in the decree, Mr. Chapman. I'm not awarding it to either side or the other, but if there's an asset that's out there that the court was unaware of, the court retains the right to divide that asset at a later date. Anything further that you think I forgot to address from either side?
There's one point. I don't believe we addressed the issue of a name change and whether or not Mrs. Isom wants that. We would not oppose it.
All right, let's reopen the evidence just to take on that testimony. Ms. Lewis, are you requesting a name change in this case?
No,
Okay, you want to, and let me ask you a couple of questions that I don't think I heard. Did you live in Texas for the 6 months before you filed this action?
yeah,
And did you live in Fort Bend County for the 90 days immediately preceding you filing this action?
yes.
All right, based on that, I'm not going to order a name change since she doesn't want it. That completes the ruling of the court. We'll see y'all back here on the 15th if you don't sign the order prior to that date. All right, thank you all. Best
Thank
of luck.
you.
Thank
Thank
you,
you.
Judge.
Off the record.